issue of rights of home buyers and investors in the real estate sector. For that, we have good pleasure of having with us Mr. Anshul Gupta. Mr. Anshul Gupta has a long experience of handling cases in real estate for the home buyers and investors as well in the courts and forums such as Delhi High NCLT, NCDRC, RERA in UP, Uttarakhand, Mohali, Haryana, etc. He has handled more than 12,000 cases. He is a dual LLM from Catholic University Lyon, France, and State University Lumiere, Lyon, France. So, welcome, Mr. Gupta.
Hi, it is nice to be here, and I would like to tell you in the first beginning that it's a very good area of practice. There's more than $2 billion industry where you can practice in and get a lot of money from there. So if you really want to get some amount of experience, you may note down with a pen and pencil before you, and you can note down all the points that can help you to get included in this industry and get money as soon as possible whenever you join this profession. So today our topic is the protection and rights of the home buyers. So if my co-panelists can share the screen, I'll like to share you some presentation that I've prepared for all of you. So it is very easy for you to take down all the points. So we are ENG partners. We practice in Honorable Supreme Court of India. We are having an experience of maybe 5 to 6 years where we specially practice in real estate laws, and we practice in all the forums such as NCDRC, NCLT, NCDRC, and state consumer, district consumer, RERA, real estate, appellate tribunals, everywhere, Delhi High Court, Supreme Court, everywhere we practice. So if we move on to the next slide, I'd like you to show you my team, my global team. Since we are practicing in this market, we have a global team of different advocates from all over the world, from Canada, Venezuela, Kenya, Brazil, North America, all of North America. Then we have in Europe, Spain, France, Germany, Russia, China, even in Ghana, then India. So we have a long list of advocates who are our advisors in real estate, and we practice generally in real estate all over the world so that we can be a niche, a mark in the world for real estate. So next slide. So my point to you is to develop that skills of a real estate attorney. What things you need to keep in mind while approaching a forum when our client comes to you, what his questions is, what your answer should be. So it should be very, very precise to the point, and you should know what is coming to you. So the generally questions comes, where do we file a case? Sir, what do we do when we file a case? So there are certain points where we can discuss it. We can give them three options, that you have three options: NCLT, NCDRC, or RERA. So these are certain options where you can file a case in India, where you can file a case in all of these forums. For example, a certain person comes to us and asks us, so where do we file a case? We have this amount of money invested in a real estate and we want to file a case. The first option should be to give them NCLT, but now as the amendment has come, the NCLT jurisdiction has increased and the minimum number of people who can file a case in NCLT is increased to 100, or 10% of the total project. This was brought to by the amendment in 2020 and by the ordinance in 2019, through which all of this came into being. The second option we gave to them is NCDRC, or state forum or district forum. So the state national forum has this jurisdiction which has been increased in this year, but it was proposed in 2019. This year they have notified it and increased it from 1 crore to 10 crores for NCDRC. For state consumer, it has been increased from 20 lakhs to 1 crores to a maximum limit of 10 crores. For a district, it is from 0 to 1 crore. So whenever you are, it depends on where do you want to file a case, what platform does he fall into, whether it is 1 crore or 10 crores or above 10 crores. So you can point out which forum does he need to go to. if he wants to go to real estate regulatory authority, it is fine. There is no bar in approaching real estate regulatory authority or real estate regulatory appellate tribunal from real estate regulatory authority. So there is no bar. You can certainly get it for unregistered projects as well. For example, there was a case of Mohammed Zain where it was said even in the unregistered projects, you can file a case in RERA and get a relief done. So these are the three forums where you have to be very, very cautious that what is the nuances of these forums and where to file a case in these forums. So if we move on to next slide, we will see the discussion on these forums. The first one is NCLT. See, when an investor is coming or a home buyer is coming, he is an investor. He falls under the investor and he is a financial debt holder. In the section 58F of the IBC, he says that if there is a financial debt was included in this section in the year 2018 after the Pioneer Urban Judgment. So they included this financial debt and they said that whenever there's a financial debt which amounts to a commercial borrowing, it can be taken into consideration and the proceedings can take place. So if you read the definition very carefully, it says a real estate project, allottee under a real estate project is deemed to have a commercial effect of borrowing, thus a financial debt. So there should be a commercial effect of borrowing. And whenever you give certain amount of money to a real estate allottee, before maybe he is putting a slab, like for a construction, he's putting 36th floor on a building. And for that, he asks you, give me 10 lakh rupees. And he takes 10 lakh rupees as an advance, which is a commercial effect of borrowing. It's a financial debt over the company. So it is a financial debt. You fall under this. Then the real estate allottee and the real estate project is defined as per RERA. So RERA in section 2D defines allottee is any person whom a plot or apartment has been allotted, sold or transferred, but not rented. So any person who has been allotted, sold or transferred a flat can be a real estate allottee. So it has an ambit of an investor or a home buyer. An investor who wants to sell it further also falls under the definition of allottee. A home buyer generally falls into the definition of allottee. So allottee is a person who has a plot, apartment which has been sold or transferred or allotted. Real estate project in RERA is any development of building consisting of apartments, conversions, development of land, purpose for selling of a plot. So anything, if you develop it for the purpose of selling, such as apartments, there's super tech, every builder is making apartments now. Any development of land, like Upal Chadda is making so many development of land. They take a piece of land and develop it and sell it to other people they cut plots basically over it. And plots for the purpose of selling, they sell plots. So they also fall under the definition of financial debt under section 58F. So whenever you approach NCLT, you should see that the conditions of section 58F should be completed. The second point it comes is section 7. When you file an application under form 1 in section 7 for CIRP, corporate insolvency resolution profession process, it is filed under section 7. So the form 1 is filled. You have to see that the form 1 conditions are fulfilled. It should be number 1 as per the new amendment. Earlier, I'll tell you what the earlier was. Earlier, the people were not included in real estate allottee, were not included in 58F. In 2018, they were included. And in 2020, there was an ordinance that they included, but the number of allottees should be more than 100 or 10% of the total project. So it came in 2020 and 2019. So the conditions for the form 1 should be complete. If you move to the next slide, you'll see the conditions of form 1. See, when the conditions of form 1 includes that you should prove the record of default, there is a record of default, your statements of accounts come into being that there is a certain kind of default, that you're paying the money, but you're not getting possession. Your agreement says you will get possession in 3 years, but you are not getting it after 5-6 years. So there is a default. There is a proposed interim resolution professional we take consent of the IRP, we take the consent of the insolvency resolution professional. He says that I will be the insolvency resolution professional and I will take over the company when it is IRP proceedings are going on. So that is that. There is a prescribed fee of rupees 25,000, which is very much like, but you are paying so much for the flat, but it is negligible for that. So there's a prescribed fee, but now they have said that these conditions should be fulfilled. That number one, there should be no proceedings against the IRP. There should be no pending proceedings. There should be proof of record of default, that there are statement of account. There should be a default as regard to agreement that it was to be given in 3 years, it is given in 5-6 years. This is the default. So when the authority sees it, the first day, if you prove this, they will issue a notice to the builder. Then the builder will reply you back, whether whatever the defense is, they'll reply you back, and then all the arguments come into being, evidence is filed, and everything happens. And authority within the 14 days, if it is satisfied that there is a default, and they will admit the application. They will admit the application. They will appoint the CIRP mentioned whose consent it was taken as a CIRP in the current proceedings. The CIRP will be appointed. So corporate insolvency resolution process begins. Section 14 now indicates it gets targeted, that there is a threshold that when CIRP begins, section 14 gets targeted. When section 14 begins targeted, there is a moratorium imposed, like all the proceedings going all over India will stop. All the proceedings, all the RERA proceedings, NCDRC proceedings, all the things will stop. Even civil court case, every proceeding will stop when this CIRP proceedings begin. So section 14 is imposed. Section 15, CIRP who is appointed will ask for the claim form. You will have to file a claim in form CA if you are an authority or operational creditor, whatever you are, you have to fill a form CA to make the claim. There's a public announcement in newspapers, Hindi and English both. Mostly it is Financial Express and Dainik Jagran or anywhere Amar Ujala, where they say that please give us all the, there's an announcement that please give us all the claim forms if you are a allottee in this project, because the CIRP proceedings has been begun. Now when he gets all the claim forms, the IRP becomes the main person. He becomes the director of the company. He is the main karta dharta of the company. He becomes the main person of the company. He takes over the corporate debtor. Now he is the malik of the company. Whatever it is IRP. So then after that, the committee of creditors are made. Committee of creditors are people who are made from the people who are allottees or operational creditors, who are allottees or operational creditor who submitted the form under section 15 when he made the public announcement. So when he made the public announcement, all the people who are giving the claim form are now committee of creditors. They are large committee of creditors, maybe 1,000 people, 2,000 people. There are large number of committee of creditors. So what happens is when the resolution, resolution professional is appointed, whether the IRP is appointed as a after IRP, it is interim resolution professional, then it is resolution professional. If he is very competent, then he will be appointed as a resolution professional. But 66% of the vote of COC is required. For example, if there is 1,000 people COC, they would require 660 votes to make him the resolution professional. Everything that happens in the company is voted by COC. It should pass by the vote of 66%. For example, from 1,000 to 660 people, 66% votes are required. So they can appoint the IRP who has consented before, or any other IRP can be appointed. Now CIRP proceeding again begins. So IRP basically begins the CIRP proceedings, which will be explained in the next slide. So there is a meeting of COC. So they will send you a e-format that there is a COC meeting. All the people who are there, you will get a chance to vote. All the resolution plan is produced before you, that this is the resolution plan, whether you want to vote yes or no or whatever it is. So you also can vote no, I do not know, like there is a balance kind of thing. So there is a process where you can vote yes or no. Then whenever you vote, your 66% takes into account whether any resolution that comes into being, 66% vote is very, very required, and anything that is above 66% gets a consent from the COC for certain actions that can be done. So 66% is minimum required. Then what happens is, since you have invested in a flat, you want to make that flat, like you want that flat to be made. Now what happens is, COC asks the people, a resolution applicant, who can make that flat. Like any other builder can come, any other association can come who can make that flat, any other private person come who can make that flat. So he files a resolution plan that I will make this flat, I will make this building. If he proposes this, I'll make this building, the IRP will propose it in his resolution plan, and the COC will vote on that resolution plan whether that person is competent or not, whether they want that person to make the building or not. When they do it, the adjudicating authority, the NCLT, may approve the resolution plan if it is approved by COC. Generally what happens is, NCLT does approve it because they know what COC is, what they know about their benefits and everything, so they generally approve it. What happens if they do not do it? In the section 633, if the resolution plan is rejected, or there is no 66% raised, or there is any contravention to corporate debtors, resolution plan, or there is any prejudice caused, so NCLT orders for liquidation. NC alters suo motu that there would be a liquidation. So liquidator can be appointed. IRP can represent as a liquidator, but he should have a consent of he should give his consent that I will be representing as a liquidator. He can be a liquidator of the company. So his job is to verify all the claims that he gets. He has the custody of all assets. He evaluates the assets. He preserves the assets. He can carry on any business for beneficial of liquidation. He sees whether all the claims are consolidated. Whatever claims he got before in the public announcement, he sees all the claims are consolidated, whether he rejects or accepts the claim. There are some people who are like filing wrong claim application. There he rejects it. So he has to see whether the claim is genuine or not. If it is genuine, then they see how they should distribute the assets. So they, under section 53, they distributes the assets. IRP says that workman is equal to the secured creditor, wages, any employees, and financial debt, so all these people are equal before the eyes of law. So thus everyone can file a claim, and the IRP will see how he can distribute the assets. So there is a general preference who will get what. So workmen, secured creditors, wages, people who had wages are equal. Then second comes the unsecured creditors, debt of the government. The debt of the government and the debt of the secured creditors are second in number. Preference shareholders and equity shareholders are second in number. So this is the hierarchy, how the distribution of assets takes place. And section 54, after the distribution of assets, there is a dissolution of the company. The company gets dissolved by the NCLT and everything goes away. So this is how you can file a claim in the NCLT, application in the NCLT, and get your money back or get your building made, whatever you want. So always remember to comply with the section 7, all the requirements, and to comply with everything that has been said in the NCLT section 7 and section 58F, so that you can file a claim in NCLT. Any appeal from NCLT will goes to NCLT under section 61, and from NCLT to Supreme Court under section 62. So you have to see where you want to go and where you want to go. So you have to see all these things. So this is about NCLT. Now I will be discussing about NCDRC, how you can approach NCDRC or State Consumer Dispute Redressal Commission or State or District Consumer Redressal Commission. So the lowest authority to file a case in consumer court is the District Consumer Court. So the District Consumer Court has a jurisdiction of less than 1 crore rupees. Earlier there was a law till 2019, it was till 2019, but it got notified in 2020. We were filing all the cases above 1 crore in NCDRC till 20th of July. but there was a notification. So we had to file all the cases in SCDRC or district consumer courts, which were above 1 crore. So we had to see that what the jurisdiction is. So in 2019, this amendment came and it has been notified now. So the district consumer court has a jurisdiction of 1 crore. Then the case moves on to state consumer dispute redressal commission, then to NCDRC, and from NCDRC to Supreme Court. So this is the hierarchy: district, state, NCDRC, Supreme Court. So the jurisdiction is 1 crore of the district consumer. For state, it is 1 crore to 10 crore. From NCDRC, from 10 crore and above. So, and any appeal can go to Supreme Court from NCDRC. So who is a consumer in NCDRC? See, a consumer is a person who avails or hires any services for consideration that has been paid or promised, or partly paid or partly promised, and includes a person for resale or not include the person for resale or commercial purpose. So a consumer is a person, for example, in our case, a consumer is a person who has availed any service. He is availing services of a builder to give him the flat. So these are services. If that flat is not according to the prescribed criteria which was set by the builder, he can approach them in the deficiency of services or unfair trade practices. For example, if there are buildings that are broken, if the builder does not provide the flat within 3 years or more than 3 years, which was specified in the agreement, then they can approach district consumer, state consumer, NCDRC. So if you will see what the deficiency of service is, if you can read it, it says any fault, imperfection, shortcoming, inadequacy in the quality, nature, manner of performance, which is required to be maintained under the law or in pursuance of the contract or otherwise in relation to any services. In pursuance of the contract, if the contract says I will give you the flat in 3 years, and if he's giving in 5 years, then it is void, like it is violating the contract. So you can approach the NCDRC or district consumer court in these forms. They can also say that there is unfair trade practice. Unfair trade practice, if you read the definition, what it says is a trade practice which for the purpose of promoting sale, use or supply of any goods, for the provision of any service, adopts any unfair method or unfair or deceptive practice is likely falsely represent. For example, tomorrow my client goes to the builder and builder says, please sign this document now, here and now, or we will forfeit all of your money that you had given in advance and will not give you the money back. The client, being scared, he signs all the documents what he says, and he does not read it. Tomorrow when he comes to us, he says that, sir, I have signed all these documents, will you please read it? And he sees all those loopholes in the contract, like which are against the home buyer, which are there. So all these things, these builders are very, very cunning people. They put all these loopholes in the contract and they try to, trap the home buyer or any other person. So it is there that people should take cognizance of it, that they should be aware that they should not sign anything there and there itself. They should take a week or half, they should read it and they should do it. And the contract clauses are very unfair. They say that if the builder delay, they will pay a delay price of 5%, 5 rupees per square feet, or 5%, for example. And if the home buyer delays, he should pay the delay percentage of 18%, which is more than triple the amount. So it is very unfair. So it is an unfair trade practice. So people, if you read again the definition of a consumer, he says hires, avail services for a consideration which has been paid, or can you move to the last slide? Yes. Hires any services for consideration which has been paid, promised, partly paid, partly promised, not includes a person for resale or commercial purpose. So this is very important. In consumer court, only people who are using it for themselves can only approach consumer forum, not for any resale, not for commercial purpose. For example, I am buying a flat for myself, I can approach. If I am buying a flat to, like I have bought 12 flats for the purpose of sale, then it is not approachable in the consumer forums. If I am buying it for myself, it can be approached. So it is very, very specific. Even a company can buy it for themselves. Even there are a lot of cases for company buying themselves. So you have to be aware whether you are buying it for yourself or any commercial purpose. If any commercial purpose is there, then they will not entertain it. But you have to go around it. For us, like lawyers, we go around it. How we prove that it is not for commercial purpose? It is very, you know, court craft that you prove it. So you have to see how you can manage the court, whether you are buying it for resale or commercial purpose, or you're for yourself. So it is very convenient for the court to tell that we are buying it for ourselves and make our application within the court, so that the court can issue notice to the builder and the case can proceed forward. Yes, please, next slide. So the jurisdiction of the district forum comes under section 34. It says that any amount which is less than 1 crore rupees comes under the ambit of district forum. So the jurisdiction, it says that where the opposite party resides or works for business or branch offices, or where the cause of action arises. There is a new addition in this Consumer Protection Act, which says where the consumer resides or works for gains. For example, I was working in Delhi and I'm residing in Delhi and I buy a flat in Noida. Tomorrow, if I have to approach a consumer forum, I had to go to Noida Consumer Forum. But now in this said act, we can approach a forum in Delhi and they have to come from Noida to Delhi because it is for my convenience. They have included this clause for my convenience in 2019 Act, that I can approach Delhi Consumer Forum and I can file my case. So it is very, very beneficial for all the consumers now. And you have to file it in section 35. There can be a single consumer who have goods sold, alleges unfair trade, more than one consumer association registered under law. So there can be a single consumer, more than one consumer, or consumer association registered under law. For example, we were filing cases for consumer association, which were more than 100. So all the people having same interest in the same property can file a case in the consumer forum. So it should be a registered organization or registered association. So you can file a case in Consumer Protection Act. The fees that is payable in district consumer forum is from 0 to 2000. There is a slab, like from 5 lakh they will not charge you any money. From 5 lakh to 20 lakh they'll charge you around 400 rupees, or from 20 to 50 I think they'll charge you 500 rupees, and from 500 rupees or 1000 rupees, and from 50 to 1 crore they'll charge you 2000 rupees. The same thing is in state forum. State forum, there is a difference in the jurisdiction. The jurisdiction is that from 1 crore to 10 crore rupees. So it is very good that there is a jurisdiction of 1 crore to 10 rupees, because there was a lot of pressure on state forums for getting all the disputes of above 20 lakhs like earlier cases. But now it is from 1 crore to 10 crore, so that can be maintained. So state forum also sees about the irregular things in the district. Like if any order that is passed against you, you can go to the state forum under section 47 that this order is irregular. Please kindly see to it and please amend it. So state forum has the power to do it. So state forum can, like in Delhi, there's a state forum here nearby. So you can go to the state forum, file a case. Any appeal from the state forum goes to the national forum under section 51. So you can go to the national forum under section 51 and file a case. So apart from doing that, the fees that is prescribed in the state forum is 2000 to 6000. So what happens in NCDRC, I'll tell you what happens. On the first date you go to the court, they'll say that if you prove that you are a consumer, they'll issue you a notice. Notice issued, reply within 30 days. The builder will reply within 30 days. If he does not, then 15 days extra is given to him. If he does not do it, then the court can proceed with the case and say that now we'll record the evidence and you can produce the evidence. You'll file the evidence. The next date will come. Next date also you can produce the arguments what are there, and then court will take into final arguments. In the next date, the final arguments will take place and they'll pass the order. So when they pass the order, you have to file an execution proceedings under section 71 of the Consumer Protection Act 2019, that the order of the court shall be passed as an order of a decree of a civil court. If they do not obey, if the builder do not obey, there's a charge of 3 years, there's imprisonment of 3 years and fine of 25,000 rupees. So you can get it complied with under section 71. So this is the main basic case in NCDRC. Whenever there is an appeal to the NCDRC, it goes to the National Forum section 51. There is a National Forum in section 58 where you can approach directly if your case is above 10 crore rupees. So you can directly approach it. The fees is minimal, like 7,500. So you can certainly do it. If we want to get a review by the National Forum, that there is an order that if you want to get a review, you can approach in section 60, or you want to appeal it, you can appeal it in Supreme Court also. So it is very, very important whenever you get an appeal or whenever you get an order, file a caveat in the upper court, so that the person who is the opposite person cannot approach the upper court as an appeal. So that there is a caveat that is filed for 60 days that he cannot approach the upper court for the purpose of appeal. So your case is saved from being appealed for the purpose of 60 days. So it is a very, it is a trickery that we all lawyers do in the consumer court, all practicing lawyers do. So you have to take that in mind. You actually think on your feet, what is going on, what is going on. So you actually see what the practice is, just to be finer than other lawyers. So yes, please, next slide. So the next thing that comes is Real Estate Regulatory Authority. So the Real Estate Regulatory Authority is in every state. Every state has a Real Estate Regulatory Authority. Haryana, Uttarakhand, UP, every state has it. So what the thing is, I'm telling you practically what happens is. So the thing is, there is different rules and regulations for each Real Estate Regulatory Authority. For example, Haryana has different filing rules. UP has a different filing rules. Uttarakhand has a different filing rules. In UP, you can file online. There will be hearing online. In Haryana, you have to file very, very cautiously, or they'll mark you a defect. You can approach Haryana, and there are certain kind of different rules for every real estate sectors or real estate forums in every state. So you have to be cautious of which state are you approaching and which forum you are approaching. So you have to see, like, if the building is in Greater Noida, you have to approach the Greater Noida court and Greater Noida court. And if the building is in near Lucknow, you have to approach the Lucknow court. So you have to see where do you want to file. So these are the certain points that you have to keep in mind while approaching the RERA. Then you have to see how you can approach RERA. See, RERA under section 12, there is the promoter to compensate for false advertisement. Whenever there is a false advertisement, just a moment, I'd like my co-panelists to produce the slides so all the students can look into. I think there is some problem, so I'll continue with it. So whenever there is RERA, under section 12, please write it down. Under section 12, there is promoter has to compensate you for the false advertisement and prospectus. When you see a prospectus, it is very gaudy. You see that all these things are there, you get really attracted to it, you pay the price. And if you do not get it, what is mentioned according to the prospectus, then there is no use of doing it. There is no use of doing it. So you have to see, you can approach RERA under section 12 that you had given these things in the prospectus and you had given a false advertisement. And now you are giving us such kind of things that it is very, very unreal for us to invest it. So you can approach RERA under section 12. You can also approach RERA under section 14 to rectify all the defects of the unit within 13 days. For example, you tomorrow take a possession of a flat. If that flat has a broken ceiling, broken walls, broken floor, everything is broken, then you can approach RERA to get the rectification of all the things that are broken within 30 days of taking possession. That, sir, I have all these things and these needs to be complied with and these needs to be rectified. Please do it. You can approach it under section 14. Under section 18, you can approach it if the builder is unable to give you possession of the agreement of sale or liable for any demand of refund or give the delayed possession both with delay, interest and compensation. If the builder gives you a possession which is very delayed, for example, you are to be given possession in 2015 and you are getting possession now in 2020. You can say to the court that I do not want the possession, I want my refund back with the compensation of MCLR plus 1, which is marginal cost of lending rate of State Bank of India, which is around 7.9% plus 1% as my compensation, plus the refund amount that I had given you. I can get that back. So you have to ask the court to give you that back. The court, if sees, then they will give you back. I'll tell you what all the case laws are for those, because there are certain case laws which you can rely on, so that court will be convinced that according to these case laws you are entitled for a refund. If there is a delay in compensation, if a delay in the flat possession, then also you can have the delay thing. You can also take the possession of the flat even if it is delayed. If maybe it should be given in 2015, if they are giving it now, then you can claim the possession, the delay interest of MCLR plus 1, which is marginal cost of lending rate again plus 1%, and the possession with it. You'll get your flat plus the delay interest of around 8.9%. So that is the amount of interest that you will be getting per year, like from 2015 to 2016, 2016 to 2017. So it will be around maybe every year you'll get 8.9%. So you have to see that how you can approach RERA. Under section 19, there are certain rights of the allottees that you have to see whether the right of the allottees are there. They should get the possession in the timely manner. They can seek refund or delay possession. They should get the interest and compensation for the both. So you can get all these things. You can get your refund, you can get a delay interest, you can get compensation for everything that is there. So you can also approach RERA if you are unregistered projects. Lot of clients come to me that, sir, we are not registered, we are not registered. We say that even if you are unregistered, you can also approach RERA. There is a case by Mohammad Zain Khan versus Maharashtra RERA, writ petition lodging 908 of 2018, where it was said that you can approach RERA even if you are unregistered a project. So it is very important to approach RERA in these forums. When you get an order from RERA, you have to get it executed, because no builder will just sit and give you the possession. You have to get it executed. Execution can happen under section 40, and for the purpose of execution, you have to comply with all the directions. The builder has to comply with all the directions, and he can do it in within 45 days from the order. So you have to basically approach the RERA for execution of the proceedings and get executed. And if the builder fails, then you have to comply with it within 45 days of the order. So there are certain relief available. If my panelist is here, he can share the slide. My students can see all the reliefs that are available in RERA court. So the relief available are the late possession. The late possession, in case the RERA seeks possession, then along with the compensation of MCLR plus 1, you can have the rate that is charged by the builder. If there is a late possession, yes, this slide, the next one, yeah, this one, can you please highlight it, or can you please, yes. So if you can see the late possession, in case of allottee seeks possession, then along with the compensation at MCLR plus 1, no, the previous, yeah, MCLR plus 1, or the rate charged by the builder. For example, if there is a late possession, he can give you the possession. The RERA can say that allottee can seek possession along with the compensation at MCLR, marginal cost of lending rate, which is 7.9 plus 1%, he can seek that, or the rate charged by the builder. If the builder was charging you 18% per annum as a late delay penalty, the RERA can also charge the builder, say that to the builder that you have to pay 18% to the allottee. So this is the beneficial thing for the real estate allottee. So even in the refund of money, the real estate allottee can ask for the refund along with the interest of MCLR plus 1. He can ask that I want my interest at MCLR plus 1, or the rate that it was charged by the builder. If the builder was charging 18%, I should get my refund back at 18%. So this is the thing. And the penalty for not fulfilling the builder duties and obligation, the rate should be decided by the builder. The interest should be decided by the forum. The forum sees that whether what kind of interest should be put on the builder for not fulfilling of its duties. So execution of the order, whatever order you get from any court, NCDRC, RERA, SCDRC, District Consumer, RERA Appellate Tribunal, you should get it executed. All the executions are filed in the section 40 of the RERA, and for the NCDRC, SCDRC, District Consumer, it is filed in section 71. So these are the current laws where you can file the case or file the execution proceedings. If you can go to the previous slide, I'll point out, the students have not seen, I'll point out what the things are. See, these are the important sections of RERA where you can approach RERA. Section 12, Section 14, Section 18, and Section 19. Section 12 deals with the false advertisement. Section 14 deals with the defects or to rectify the defects. Section 18 deals with the refund amount or delayed possession. Section 19 gives you the rights of the allottees. And even the unregistered projects, that is, can be approached in Mohammad Zain Khan versus Maharashtra. So if you have a pen and paper in your hand, you can write down certain case laws which you can produce before the court, that these are the case laws on which I am relying to get my refund back. These are not written in the slides. I am telling you verbally, as I did not get the time to write it down. So the first one is Pioneer Urban versus Govindan Raghavan. It is a civil appeal number 12238 of 2018. It says that possession can be given, possession if it is not given within a reasonable time, refund can be asked. It is the Supreme Court judgment. No court will deny it that you cannot, we will only give you possession or anything. Every court will see it and say that we'll give you your refund back. The second is Kolkata West versus Devashish Rudra. It is civil appeal number 3182 of 2019. The next is Lucknow Development Authority versus M.K. Gupta, AIR 1984 of 1787. The next is Fortune Infrastructure versus Trevor Dilemma. It is civil appeal numbers 353, 3534 of 2017. And Bangalore Development Authority, civil appeal number 5460 of 2002. So all these cases are for refund. If you want a refund, you can cite all these cases and get your refund. The next case laws I will be telling you about is the delay penalty. The delay penalty is K.A. Nagmani versus State of Karnataka, Karnataka Housing Board. It is civil appeal number 6730 of 31 of 2012. Next is Ghaziabad Development Authority versus Balbir Singh 173 of 2002. So all these cases are for refund and delay penalty. So you can get the delay penalty of 18% if you want. You can cite all these cases and you can get it there. So all these forums are there to approach to get your refund or your possession from the builder. If you move on to next slide, I'll tell you that certain we have assisted more than 120 crores as a refund of money and given peaceful possession to more than 3,000 home buyers. That's a large number of people. I told you it's a very big industry right now. It's more than $2 billion industry in India. In India, if you want to do it, you can do it really, really good because it's a very niche industry. No one has been seeing all these things. So it is better to do a specialization in a single place. Though if you move to the next slide, you can see all the testimonials my clients have written to me. that Mr. Gupta is a real review based on personal experience and a genuine lawyer. And in this era of greediness and unfair practice, it itself a challenge of a common man. The law firm is made of real gems who do not make over promises, no false hope. So all these things are there. So uh, people write to us, you get good wishes from everyone. Everyone writes you good wishes on Google, everywhere. So it is a very good industry to practice in. I would request everyone to give it a thought so that it has money. Number one, what you need is to go out of the school is to get money. It is a good place to get your money. So it is certain things. So you can look into it. If you move on to next slide, there are certain testimonials as well. Then if you move to next slide, you will find we are doing certain cases with Mr. MC Mehta. We are doing it pro bono because we care about environment a lot. And we are protecting the archaeological sites, the construction of metro, all these things. For the forests are being preserved, the bird sanctuaries are being preserved. We are covered in lots of newspapers and everything. So in Taj Trapezium Zone, we are doing it with Mr. MC Mehta and everything. So we are a very big organization where we do all these cases, and it is very we feel also good to do all these cases with Mr. MC Mehta. So our practice is very large. We try to concentrate on real estate, but we do all these practices just for the purpose of our own sake and our good gesture towards the society. The next, we are doing it with Government of India. If you can move to the next slide. We are doing policy works with Government of India, and we are doing land registration works. We are going to different talukas to see whether the land registration work is going or not, or whether the process of electronic registration is there or not. So all these things are there. And if you move on to the next slide, I'll thank you that you were here to patiently listen to us, and it is an honor for ANG Partners team and to guide you in the process of real estate. And we wish you all the best for your future. And if you have any questions, you can certainly ask us. And we would also like you to gather some information what the real estate industry is, because for me, I'm telling you, it is a very big industry. If you want to get out of the rat race or everything, then you have to get into this industry to get money or proceed further with your cases. So that is the thing. Thank you.
Thank you so much, sir. I think we can take up the questions as of now. We have, I can see 4 questions. Let us, we had questions even before that. Unfortunately, I was dropped off because of the bad weather. So if you can also check the Q&A button, I lost some from there.
Yeah, I can see one. Sir, can we demand refund as per market rate or ready reckoner rates of the property prevailing instead of the interest and the compensation? You can demand refund at the rate that you had given. See, when you have paid 20 lakhs to the builder, you can get that refund back of 20 lakhs plus the market rate. Like, it is not the market rate, it is the marginal cost of lending rate. Whether there is SBI has a marginal cost of lending, MCLR, you get it at plus 1% from RERA. NCDRC, SCDRC, District Consumer Court, all these give you at the rate of 12% or 18%, however you convince the court. Whatever you want, you can convince the court that I want on this rate, they'll give you on this rate. So these are the way you can get your compensation, all these things back. The next question is for Naseem Sheikh. Yes, I think he or she was writing for me to write down all the judgments. I'll send it to Akshay, or I'll send it to Akshay, and he'll write it down all the judgments for you, and you can take all the judgments from him. And whenever you approach the courts, no court will deny you from getting any refund or delay back, because these are Supreme Court judgments which are tried and tested. So the next question is, it was a very insightful session. Thank you. Can you please provide the presentation at the end of the session? Yes, Akshay has the presentation and he will provide you the presentation. You can look into it, you can practice it. You can also share it with other people as well. So you can develop that area of real estate. that area of real estate, if you can develop it, if you can do it, it is very good. Because since I've been telling again and again, it's a very good industry to practice. And if you are a junior, if you are anyone just getting out of from the college itself, you can still practice it. Because it does not, it is a very niche area. There are not so much lawyers in it. So you have to grab it and grab this opportunity, so you can approach all these forums. So the next question I got is from JS Pawar. Which forum, RERA or consumer forum, should be approached in the cases, and what are the different implications? See, it depends on the client, what client wants. If the client says that I want to approach RERA, you can approach RERA. If he says I want to approach consumer forum, you can approach consumer forum. It is your duty to tell him that there are real estate for a RERA, there is RERA, consumer forum, or any other forum that you can approach like NCLT or this. So it is your prerogative that you have to tell the client that these things are there. Which forum do you want to approach in? There is a question by Naseem Sheikh. Does industrial unit purchaser is a consumer? If you buy an industrial unit for your own purpose, if you buy an industrial unit for your own purpose, then you are a consumer. But if you buy it for if you buy it for commercial purpose, but industrial unit does not cover it, because you're using it for commercial purpose. But if you would buy it for your own good, for your own purpose, that I'll be using it, I'll be doing all of these things, then it will form, he will be a consumer, and he can fall under the definition of consumer. The next question is of Vivek Mashkar. In case matter related to delayed possession for unregistered project in Mumbai, if payment made is almost 50% of the flat value in exchange of an allotment letter in 2014, how one should go about it to claim refund of amount paid along with the compensation? Which forum give a suitable remedy at this juncture, where there is nothing has been done by the developer? Recently, Maharashtra RERA Authority Chairman Mr. Chatterjee is giving benefit of pioneer land judgment and says unregistered projects are out of purview of RERA. So where should one go about it? The Maharashtra is not taking cognizance of writ petition 9028, and how should one go to about? See, if they are not taking cognizance of it, you can approach consumer forum, and consumer forum will take cognizance of it. So you have different forums. You can go to any forum that you want. If one forum is not entertaining, you can go to a different forum, and they will certainly entertain you. As I told you, the different judgments of the Supreme Court, you can produce them before the Honorable Court, and they'll be very happy to give you all the refund back with the interest. So yeah, Muktara Chingapar writes, thank you very much for informative session. Thank you very much for staying and asking questions. Thank you. Any other questions if you guys have, you can certainly ask me. I'll be obliged to answer it, and we can take this forward from there. I hope everyone...
I can, if we have little more time, I can take the questions from the Q&A box.
Yeah, please.
There is this one question even I wanted to, I wanted you to address. It's a comparison between all the three forums available. Although it is very case subjective that which forum to approach, but can you make a general comparison, or can you give out some pointers to make a judgment about which forum to approach?
As I already said, it depends on the client, which client wants to go in which forum, and he is the sole person who wants to go to a forum. Your job is to tell him that these three forums are there. What forum suits him well is his prerogative, whether he wants to go there or not. So all these things are there. So it is his judgment where he wants to go, which forum does he wants to go. He wants to go to RERA, NCDRC, NCLT, whether he wants to go anywhere. So it is his prerogative. So he has to see. Anita Bhatia asked a question, but I cannot see her question. If you can write it again, I'll surely answer it. Naseem Sheikh writes very informative. JS Pawar says that is limitation of 2 years is applicable in real estate consumer cases too, and how to make continuous cause of action. It is a continuous cause of action if he gives you a demand letter that please give us the money, or please give us this thing, then it is a consumer, then it is a continuous cause of action. It will continue till the time the possession is not given. So it is a continuous cause of action. There's a judgment of the Honorable NCDRC. You can refer to that. I think I might have it on my table, but it's very far. I'll reach it and then I'll tell you. Can we approach different forums simultaneously? Yes, you can approach different forums simultaneously. It was decided in Pioneer Urban versus Union of India, where you can approach NCLT, NCDRC, and RERA simultaneously. But RERA has a clause in section 71 that when you have filed a case in RERA, you have to withdraw your case from NCDRC or any district consumer forum. So you can approach all the three forums parallelly. It has been decided by Supreme Court in Pioneer Urban versus Union of India. You can certainly do it. So next question is by Hirkesh Singh. So being a civil engineer plus LLB, is it of any help in getting clients? Sir, even I know a doctor who is LLB and he still gets clients. So I think it is your capacity to gather clients on take clients. It depends on you. Yeah.
Right. So I had one interesting question on the box. So this person has paid certain amount to the builder who had promised to, return it to him, and the due date was after the lockdown happened. So there was this period of 6 months. So the builder said that he would give it back after the 6 months. So what happens if the builder does not refund the amount in next 6 months, and what options are with him? In this regard, I wanted to ask about the extension given by the various notifications. So let's say, is it only about the due date, or is it also about such refunds to be given? A, and B, if let's say the date is March 25 when the extension happened, and a due date for a project was, let's say, April 25. So this 1 month which is there, would it be added to the extension, or will it not be added?
See, the simple rule is there was an extension by Ministry of Housing and Urban Development. A notification came. They said that they would be extending it till from March till September. So in September, it stopped. Now, if you are claiming, if they said that they would be giving, now you can claim it in a court. You can go to RERA, you can go to Consumer Court and say that I did not get my possession back. Please give me please give me my possession with delay penalty and interest. So kindly give it to me. If you can read, Akshay, there is a notification by Ministry of Housing and Urban Development that the period from March till September is taken as a force majeure period. So this is a force majeure period. Nothing can happen in this. So whatever you have to file is after September, and it is a really nice time to file now. You can file every complaint, and you can certainly get all the refunds and everything back. Even every court is giving you now. Every court is taking all these matters, and they'll certainly issue notices and give you your dues or compensation, whatever you want back. So I get a question from Anita Bhatia. I asked whether refund for cash payments made by builder can be claimed, especially where there is no receipt. Only proof is 12% assured return paid by the builder. See, there is a very difficult thing on whether cash payment can be claimed, because if you had a receipt, it would be good, but if you do not have it, it is very difficult to do it. So the proof of 12% assured return is paid by the builder. I think 12% assured return is can be like, you can get 12% assured return. If he stopped paying you, then you can approach the court to get it, to get the dues paid and get your assured return paid, or get it started again, because I think in the lockdown they were not doing it, and they can do it again. The next question is by JS Pawar. How to tackle menace of absconding or non-found builders and recover refund or get possession in the field project? See, you can file a case in NCDR, in Consumer Forum or RERA. They'll issue an order, and if they do not, if the order is issued, you can file it for execution. In Consumer Court, it is a decree of a civil court. They will call the builder. If he does not produce himself, then they'll issue a notice, or they'll issue warrants against him as to imprison him for more than 3 years. and a fine of 25,000. And RERA also does it. If they do not approach it, RERA also has the same power of 5% of the project cost, imposement, and three years of jail time. Then the thing is, how to Nitesh Bharadwaj asks, how to know whether land is allowed for construction or not? What makes it registrable or not? See, you have to see whether the land is allowed for construction, not with the Industrial Development Authority. Like here, Yamuna Expressway Industrial Development Authority is there, Greater Noida Development Authority is there. So you have to see all these things. Okay. Then Muktaria Chingappa writes, what about conciliation and mediation process in UP, Haryana, RERA, Maharashtra, Karnataka? Already recognized the same. Yeah, it is still going in UP and Haryana also, mediation process. We have done a lot of mediation processes in UP and Haryana. That is fine. What are the three specific prayers? What are the specific prayers under all three acts? It depends whether you want refund. The second is whether you want possession plus interest, refund plus interest, any other mental harassment, litigation charges. So all these things you can ask. So there is, I think all the questions have
Yes.
distinguished, and I think those are the.
Yes, we have taken up all the questions. I hope everyone have got this. So thank you very much, each one of you, to join us today. Thank you so much, Anshul sir, for taking out your precious time.
Thank you for inviting me.
I hope that we get to hear from you and we get to do such webinars with you again. So thank you so much. I'll be just concluding the session.
Sure. Thank you. Thanks a lot.
Good evening. Bye.